Guys, these next few topics, I'm not going to take you into the standard. You can go and quickly have a look. There's nothing there that's so crucial that I need to point out in the lecture. You'll have the highlights and you can go and do that. So just to see the categories of companies, we either get profit or non-profit. Your different types of profit: state-owned, public, private, personal liability, and then non-profit is just the one type. Okay, state-owned, guys, obviously the state owns them. Public, this LTD means public, not listed. Okay, so if you see LTD in a question, you can see they are a public company. In order to determine if they are listed, they have to say they are listed. Okay, private, Pty Limited, this means that there is a restriction on the shareholders. It is only the shareholders who were invited to be shareholders of that company, versus public, it is open to the public. That is why it's called public. There's no restriction on the shares. Personal liability is a private company. The only difference is that the shareholders share in the liability of the company. And those are all the little designations for them, just so that you know when you get a question, what am I dealing with? As we work through the Act, we will learn how public have certain restrictions and requirements, private, and so on. Okay, I said I want to discuss the Memorandum of Incorporation. So we said that this is the document that details everything NB about the company. So it's got the name, the number and class of both authorized and issued shares. So every time there's a new issue, they are going to have to update the Memorandum of Incorporation to show that there's been a new issue or a new class has been issued. They've got the name of directors and shareholders. So every time there's a change here, they have to go and update the MOI to ensure that it is up to date with the correct information. And it'll have any rules, rights, and duties of directors and shareholders, and any other rules, rights of the shares that they have in issue and or have authorized them. Okay. Amending the MOI. I know this was a level 2, but I said I still want you to be aware of it. They can amend this if the shareholders pass a special resolution. And guys, later we're going to look at the fact that shareholders have 2 different types of resolutions they can pass. One that's not as strict, that requires less to vote in favor, which would be an ordinary, and then a special, which requires quite a lot of shareholders to vote in favor. So if they want to amend the Memorandum of Incorporation, more shareholders are going to have to be on board because a special resolution will have to be passed to do so. If they are wanting to amend the Memorandum of Incorporation because of a share issue, then the directors can vote and pass the resolution to amend the number of shares issued, because as we learn at a later stage, it is the directors who are going to be responsible for authorizing the issue of shares. And so if they authorize the issue of shares, if they have the ability in the MOI to amend by passing a resolution, then they will be able to amend the MOI too, because of the new issue that's taken place. Okay, guys, remember, your issued should never exceed your authorized. Because you should only be able to issue what you have available, which is authorized. So if they do issue in excess of their authorized, then they're going to have to go and change the MOI, not only to include the new issue, but to update the authorized, to increase, to ensure that the authorized is not exceeded by the issued. Okay, the validity of companies' actions. If any action that takes place within the company contravenes the Companies Act, it is void. It cannot happen. The Act tells you, if you do this, it is wrong, then they cannot do that. Okay, so very important to see. If you're seeing they're doing something against the Companies Act, you can say that is non-compliance with the Companies Act, and therefore the decision or the action is void. If, however, the action is allowed in the Companies Act, but it contravenes the MOI, and that's maybe because they've put a restriction in the MOI that is stricter than the Companies Act, and so it contravenes the MOI, but the Companies Act still allows it, then it is not void simply because it contravenes the MOI, because it doesn't contravene the Companies Act. The directors and shareholders are going to have a look at that to see if they need to amend the MOI or to authorize that decision, but as it stands, it could still be held valid even if it goes against the MOI. Okay, and how do they go about ratifying or accepting that? The shareholders will pass a special resolution to say that action is actually fine even though it contravenes the MOI, or I'm going to amend the MOI to make sure that the action isn't in contravention of the MOI. Okay, and pre-incorporation contracts, the last little topic I want to look at here in this recording. If they want to enter, so now it would be your owners, your shareholders, want to enter into a contract before the company has been incorporated. So they haven't registered it yet. Maybe they've applied for it to be a registered company, but it hasn't gone through yet. But now they've got this opportunity to enter into a contract, and they want to take that opportunity. You can enter into the contract before the company is incorporated. However, very importantly, if you do, you will be jointly and severably liable for any liabilities. If the entity is never incorporated, so they don't incorporate, and you've still entered into this contract, or if after they are incorporated, the contract is rejected, and there is a limit. You've only got 3 months as a business to reject this contract from incorporation date. So basically they're saying, enter in before you get incorporated. Provided once you get incorporated, the decision or the contract is accepted, your joint and several liability falls away and the contract is now with the company. If, however, the company doesn't get incorporated, there is a contract that you signed, you are now going to be held jointly and severably liable for that, because the company isn't going to be, because it never got incorporated. Or if after incorporation they decide, nah, don't want this contract, you will be jointly and severably liable with whoever else passed that decision. So what happens if it is accepted on incorporation? Well, then it's nice and easy. Your joint and severably liable for the liabilities ceases. So you're no longer jointly and severably liable for the liabilities. It now becomes the company's responsibility because they are involved in the contract.